All right, welcome back. Fifth and Sixth Amendment. All right, so we're going to start with the Fifth Amendment. You have the text here. You can pause and read through it if you'd like to, but things like grand jury, no double jeopardy, you can't be compelled to testify against yourself, so no self-incrimination, eminent domain, and due process of law. These are our Fifth Amendment rights. Now, the reason they're important right now is that we recall that these were protecting us from the federal government. Likewise, the Sixth Amendment promised us that we could have speedy and public trials with an impartial jury, and then that last part, and to have the assistance of counsel for his defense. So these were all promised by the Fifth and Sixth Amendment, but initially these protections were only offered or guaranteed in federal cases. That obviously is going to change to where it will be applied by the states, and we see that happening again through selective incorporation, through the interpretation of the 14th Amendment's Due Process Clause, which incorporates these fundamental rights on a case-by-case basis. One of these is the Miranda rule, which says that not only is it that suspects in state trials have Fifth and Sixth Amendment rights, so things like right to a trial by jury, that they have the right to an attorney, that they have the right to due process, all these things, but states have to inform people taken into custody of those rights. So the Miranda rule does not actually give anybody any right that he or she didn't have before, but it is making the rule that police must inform suspects who are in custody of these rights that they have that are found in the Fifth and Sixth Amendments. There is, however, a public safety exception, and that exception is that if the question is asked in order to neutralize a dangerous situation and a suspect responds voluntarily, the statement they make can be used as evidence even though it may have been made before the Miranda rights were read. All right, so we have a key exception here based on public safety. So in that moment, the situation is dangerous. They ask a question to neutralize that threat. If the suspect voluntarily responds, yes, that evidence can be used against that person in trial, even though they made that statement before their Miranda rights were read to them. Gideon versus Wainwright, 1963. This is a landmark Supreme Court case. It incorporated the right to counsel. So, like it says in the Sixth Amendment, that you have the right to counsel to assist you in presenting your case in trial, in court, this now says that states have to give you that right to counsel as well. When we say counsel, we mean attorney. The idea here, prior to this case, only the federal government had to do this. Now states do as well. I have a video all about Gideon versus Wainwright, so check that out for a little bit more detail on that case. All right, subscribe if you haven't already. Don't forget, hit that like button for me. This has been a LaMoney Production.